Good afternoon, everyone. Welcome to this House Percival webinar, Company and Commercial Law Update. We have an hour of content to deliver to you in 4 different sections, so there will be time for questions at the end if you have any. There is the chat function on the webinar. If you have any technical problems, we've got a support team there available to help you. If you do have any questions, please put it in the Q&A on the webinar settings, and we'll do our best to answer them at the end, or we'll follow up with you separately afterwards. We're also very keen to hear your feedback on the event, on the topics that we've chosen to present to you today, and also what are the topics you might like to hear from us. So please do let us know, give us any feedback, but all gratefully received. Just by way of introduction, I'm Paula Dumbill. I'm a partner in the commercial team at House Percival. I specialise in commercial and technology contracts, and I work with businesses on outsourcing arrangements, supply contracts and service delivery. I'm joined today by my colleague Chris White, who's a director in our commercial and technology team. Chris advises on a range of commercial contract and trading arrangements. He's got considerable experience with technology businesses and also warehousing and logistics, and has worked a lot with major UK retailers. We've got Danielle Chetwynd. Danielle is a director in our corporate team who's experienced in mergers and acquisitions, restructuring complex corporate reorganisations. And last but by certainly no means least, Jeremy Hyde, who's also a director in our corporate team, who advises on a range of corporate matters, including company assets and disposals, and also employee ownership trusts. Danny and Jeremy recently been promoted to director at House Percival, so congratulations to them. In terms of the agenda that we're going to cover today, the purpose of the session is to highlight what we see as the key legal issues coming down the tracks that all of us as business advisors should be aware of over the coming months. It is intended to be a bit of a kind of bird's eye view of key legislation and what it might mean for each of us as business advisors. There'll be sessions. The first one will be the UK National Security and Investment Act, where Danielle will talk about when it might apply and what its impact is on deal making. Chris will then look at data security and privacy, some of the changes coming down the tracks. I'll do a session on ESG in the supply chain and the move towards mandatory supply chain due diligence. And then we'll have Jeremy that will talk to us about the Economic Crime and Corporate Transparency Bill and what reforms we can expect to Companies House. So that's the agenda. So we've got an hour's worth of content. So with that, with no further ado, I'll hand over to Danielle to talk about the UK National Security and Investment Act.
Sorry, rookie error there, I was on mute. Thanks everyone for joining. So the National Security and Investment Act 2021, what is it and what's its impact on deal making? Next slide, please. The National Security and Investment Act 2021 is a huge extension on the government's powers to review mergers that might affect national security. National security is not defined within the legislation, so it has a very broad application. Control thresholds are as low as 25% and there's no de minimis value for transactions. It introduces 2 regimes, so a mandatory regime for those that fall within the 17 sectors, which are known as the sensitive economic sectors, and a voluntary regime for all other areas of the economy. So the voluntary regime applies to all areas outside the economy, and parties are encouraged to notify trigger events that they consider may be of best interest from a national security perspective. So the government has expansive calling mechanism to review non-notified transactions up to 5 years post-completion. The calling period is then reduced to 6 months if the government's become aware of a transaction. Next slide, please. So this slide here shows the 17 sectors for mandatory clearance. So where someone operates in these 17 sectors, if there's a trigger event, then they have to be notified. The actual intricacies of what these areas mean is on the government website with further details of guidance. For example, the transport sector doesn't apply to all transport, it's very sector specific, with example rail rather than all transport in general. If it's a mandatory regime within these 17 sectors, a trigger event would be as low as a 25% shareholding being acquired, but also can apply to things like assets that are being acquired. And on the topic of assets, so it's not, this regime doesn't just apply to mergers and acquisitions, sales and purchases of businesses. It can apply to land agreements which were brought into scope sort of 10 years ago. It applies to the contracts for the sale of land. Any assets deals would be subject to the non-mandatory clearance regime, where the acquisition of a certain asset might be sensitive. For example, if there was a piece of land that was subject, which was close to a government building or telecoms equipment nearby, which might be sensitive. But assets can also include intellectual property and any other assets such as equipment and machinery. Next slide, please. So how might your business be affected? So the government has the power to review or call in deals which take place after the bill was published. So that's deals that were entered into after November 12, 2020, but the full regime only applies from the 4th of January. Failure to comply results in heavy sanctions. So you can, there's turnover-based fines, prison sentence, etc. It can also mean that your transaction is void. So if you've gone to the trouble of purchasing an asset or purchasing a business, that transaction will be void if clearance was needed. You need to ensure that you factor clearance times into the acquisition. So if a proactive notification is made, the Secretary of State has 30 working days to issue a calling notice. And where calling notice has been issued, Secretary of State determines what remedies to take or what the next steps might be. But there's a 30-day working preliminary period, which can be extended by a further 45 working days. And then that clock is paused if further information is required from you whilst they're considering that application. So that can have quite a significant impact on timings for a transaction. And also specific due diligence and appropriate warranties to be included in the acquisition agreement. So you want to ensure that firstly you've made the right inquiries and ask the right questions during due diligence so you can fully understand the scope and make sure that you've got adequate protection or you've got that clearance if you need to get it. And then secondly, to have the appropriate warranties in an agreement to make sure you've got some sort of contractual protection if clearance was needed and wasn't obtained. Next slide, please. I think that's it. Yep, that's all for me on the NSI Act. If you've got any questions, put them in the Q&A section and we can answer them at the end.
Thanks very much, Danielle. If we can now hand over to Chris, and Chris is going to update us on data security and privacy.
Thanks, Paula. My talk will be providing a whistle-stop tour of some of the main changes to data protection and privacy legislation proposed by the Data Protection and Digital Information Bill. This was laid before Parliament on the 18th of July 2022, following consultation by the government. It was stalled somewhat after the first reading due to the chaos around the Tory leadership election and also Liz Truss's short-lived premiership, but also to allow further consultation with business leaders and data experts. The bill was reintroduced by the government in March this year, imaginatively titled the Data Protection and Digital Information No. 2 Bill. And we're told that the legislation is a crucial part of the UK data strategy, which aims to demonstrate post-Brexit opportunities for unlocking the value of data and also to secure a pro-growth trusted data regime. The bill proposes changes to UK GDPR, to the Data Protection Act 2018 and to the Privacy and Electronic Communications regulations, but the familiar principles and frameworks of GDPR remain in place. The bill really contains a mixed bag of provisions aimed at reducing the regulatory burden. The bill is actually currently going through Parliament and only, I think, yesterday completed the committee report stage. So the next stage is it's going to its third reading before it goes on to the House of Lords. So I'm going to look at just a few areas that I picked that have relevance to amendments to GDPR. And the first of those is the lawfulness of processing. So if you could take the slide onto that, please. Next slide. That's it. Right, so the first data protection principle states that data must be processed lawfully, fairly, and in a transparent manner. And Article 6 of the GDPR actually sets out the grounds for lawful processing. That includes where you're processing for performance of contract or where you have the consent of the data subject. One of the grounds, though, and one which is used very often as a sort of sweeper up for everything else, is processing. The processing is in your legitimate interest. And that's where processing is necessary for the purposes of the legitimate interest pursued by the controller, but subject to such interest not being outweighed by the data subject's rights and interests. Now, the new bill makes two proposals with regard to legitimate interests. The first, it actually introduces some examples of circumstances which are acknowledged as being legitimate interest. And there are three examples that are given by the bill: processing where it's necessary for direct marketing, intragroup transmission of data for administrative purposes, and processing that's necessary for ensuring the security of a network information system. Now, in each of those cases, whilst that will be recognised as legitimate interest, you still need to weigh up that legitimate interest against the data subject's rights and interests. The second thing regarding lawfulness of processing that the bill introduces is a new concept of what they call recognised legitimate interest. And these include national security, public security and defence, detecting, investigating, and preventing crimes and apprehending offenders, safeguarding vulnerable individuals, and democratic engagement. And this list, that's the current list, but this list can be amended from time to time by the Secretary of State. The circumstances listed will be relatively rare for the private sector, but where they do apply, the party claiming a recognised legitimate interest is automatically regarded as having a legitimate interest without the need to balance the controller's need against that of the data subject. The one area that may be of more relevance to private practice relates to the detection, investigation and prevention of crime, because that covers economic crimes such as fraud and money laundering. And this may be useful to businesses where they carry out the types of checks, those types of checks on their customers. So that's legitimate interest. Right, moving on to data subject rights. Article 12 of GDPR provides that a controller can charge a fee or actually refuse to provide assistance for a data subject right request, where that request is manifestly unfounded or excessive. And the burden is on the data controller to prove that. The new bill actually introduces a new test. So rather than being a requirement that the request be manifestly unfair or manifestly excessive, the new test is that you will be able to rely on an exemption where the request is vexatious or excessive. And the view predominantly is that that potentially expands the circumstances in which data controllers can either refuse a request or make a charge for that request, for dealing with that request. The bill sets out various factors which were taken into account in determining whether a request is vexatious or excessive. And those include the relationship between the data subject and the data controller, the resources available to the data controller, the extent to which the request repeats a previous request from a data subject, how long ago the previous request was made, and whether there's any overlap with other requests made by the data subject but to that controller. There are some examples given of requests that might be considered vexatious, and that includes requests that are intended to cause distress, requests not made in good faith, and requests which are an abusive process. And as I say, the predominant view is that vexatious and excessive is a lower threshold for applying the exception, and it could help address the risks of weaponizing the use of data to subject access requests, which is becoming very common these days, particularly in areas such as employment, because the view could be taken that making a subject access request as a way to bypass the court disclosure rules is an abusive process, which is one of the examples given of a potentially vexatious request. Right, moving on to the Information Commissioner's Office themselves. The one thing to note about this is that they're changing their name under the, well, if the bill goes through, they will. Instead of being the Information Commissioner's Office, they will simply become the Information Commission. That new commission will be made up of a board of executives and non-executive members appointed by the Secretary of State. And perhaps most significantly, the Secretary of State is going to have the power to designate a statement of strategic priorities, an SSP, relating to data protection, and to require the Information Commission to have regard to those priorities when they're exercising their functions. So whilst the ICO is not legally required to comply with them, it must have regard to the statement of strategic priorities. The concern there is that that will increase political influence over the Information Commissioner, the Information Commission, eroding its independence and possibly sort of politicize the activities of the Information Commission. Another area that is covered, next slide please, is data protection impact assessments. So this is the obligation that's set out in GDPR to assess the risk of processing activities where there's a high risk to the rights and freedoms of individuals. What's new? Well, the test remains the same, but the name is changing. They'll no longer be known as DPIAs, but assessments of high risk processing, so presumably AHRPs. Also, the list of circumstances which is currently set out in the GDPR where a DPIA has to be undertaken is being removed. And instead, what's envisaged is the Information Commission will publish a document containing examples of the type of processing which it considers to be a high-risk processing example. You can still undertake a DPIA or an AHRP if you want to, in the same way that you can at the moment. You don't. It's not that you only undertake them where you have to. A difference is that under the existing regulations, if a DPIA indicates a high risk, then in the absence of any measures to reduce that risk, you are under an obligation to consult with the ICO about that. Under the new bill, where the assessment indicates a high risk, the controller may, but is not required to consult with the Commission. However, the one thing worth keeping in mind is that voluntary consultation will be treated as a mitigating factor during any subsequent ICO investigation or enforcement action. So it's always worth keeping that in mind. The last point on this, and this is a point that applies to a number of the amendments, is the UK-EU position, because this bill will make changes to UK GDPR. But if you are a business doing, which is basically caught by both UK GDPR and EU GDPR, then you will still be subject to the EU GDPR rules with regard to your activities that fall within that regulation. And to the extent that you have two sets of regulations applying to you, even though the UK regulations, the whole point is to try and make things administratively a little bit simpler. If you're also subject to EU GDPR, then it's likely that you will go to and operate to that level simply because that sets a higher benchmark. And if you do everything in accordance with EU GDPR, you will still be complying with the UK GDPR. So that's something just to bear in mind if you fall within both sets of regulations. The next area I want to talk about is data protection officers. Some of you may even be data protection officers, but not for much longer. If the bill has its way, you will become senior responsible individuals instead. And at the moment, the test for requiring the appointment of a data protection officer, in addition to public authorities, is that you're required to appoint a DPO where the core activities of the business consist of systematic monitoring of data subjects on a large scale or large scale monitoring of special category data. So it very much relates to the volume of monitoring that goes on. Under the new bill, an organisation will be required to appoint an SRI where the organisation carries out processing which is likely to result in a high risk to the rights and freedoms of individuals. So whilst the previous obligation related to large-scale processing, it's now very much the test is related to the risk, not the volume in the processing. Therefore, organisations that didn't previously require a DPO may be required to appoint an SRI if it processes small volumes of very high-risk data. The other change in relation to the DPO or SRI is that the SRI must be a member of the senior management of the business. Currently, the requirement for data protection officers to be able to act independently often means that the data protection officer isn't actually a member of senior management. So businesses will need to look carefully at who they appoint as the SRI. The other thing that will need to be kept in mind as well is the appointment of external DPOs, or SRIs as they will become. This will need to be reviewed, although it will still be possible because it is possible for the SRI to delegate their obligations. Therefore, if the SRI delegates to an external organisation who report to the SRI, then that should still be acceptable. And again, this is another of those circumstances where different rules may apply to different processing if you happen to be subject to both the UK GDPR and the EU GDPR. The final thing that I wanted to just talk about is the privacy and electronic communications regulations. So various changes are being made here. The bill widens the situations in which cookies can be used without the user's consent. So in other words, where an opt-out could be used instead of the requirement to obtain consent. At present, that only applies to the placing of strictly necessary cookies. But the proposal is to extend that to allow you to place cookies without consent, where the cookies make improvements to a website, service or app, where they allow the appearance or functionality of the service or website or app to reflect the user's preferences, or where the cookies update software for the security of the device. So in those circumstances, the proposal is that that should be allowed to be imposed without the need to get your specific consent. There's also provisions regarding the management of cookie preferences. And the provision is that it is to allow the Secretary of State to make regulations enabling cookie preferences to be managed using alternative preference management systems that will be sort of either browser-based or device-based opt-ins. Now, there have been similar provisions to this introduced before. We're giving the Secretary of State this power, which haven't been used, but it could go some way to improving the user experience in relation to the multitude of sort of cookie consent banners that we all get when or basically bombarded with whenever we sort of go onto a new website or a website we haven't visited for some time. There's also provision to extend the soft opt-in. Now, the soft opt-in is the mechanism that allows you to carry out direct marketing emails to existing contracts in respect of similar products, as long as you give them an option to opt out. That soft opt-in is basically being extended to direct marketing for charitable objectives and political objectives, as well as any other non-commercial objective. And then finally, enforcement. The enforcement powers under the privacy and electronic communications regulations, which currently have a maximum fine of 500,000, are being brought in line with the fines under the GDPR and the UK GDPR. So that will be the 17.5 million or 4% of annual worldwide turnover. So there's a significant increase in the fines available. The last slide I've got is just to make the point again that basically there is the difference between the UK and the EU position, which businesses will need to take into account when considering whether to adopt any of the reduced administrative burden that is being imposed by the new bill. And also to make the point that the changes, there may well be changes to this during the legislative process. As I say, it's now just about heading to its third reading, then it will go on to the House of Lords, and there may well be changes that come into effect during that period. That's it, thank you.
Thanks very much, Chris. I'd like to move us on to a different topic now, onto the subject of ESG in the supply chain and the movement that we're seeing towards mandatory supply chain due diligence. I want to cover three different areas. First of all, the current regulatory and voluntary frameworks that there are for ESG. I want to talk about some of the roadmap for compliance, so where it looks like we're heading on compliance issues. And then thirdly, I want to look very briefly at an increasing area of focus, which is the reputational risks that are coming to the fore in the ESG arena, and specifically greenwashing and what we think we can expect going forward. So to build a picture from the ground upwards as a quick overview, what do we mean by ESG? Well, ESG stands for environmental, social, and governance, and it's really about the way that companies and investors and stakeholders are thinking about a whole raft of issues like the environment, climate change, and sustainability. In 2019, the UK set itself a net zero carbon target for 2050. So what measures are businesses taking to ensure the achievement of that target? It's also about workplace safety, diversity and inclusion, evolving expectations about corporate behaviour. It's about relationships with employees, with suppliers and customers. You know, we're all consumers. As consumers, I think we're all actually wanting to do business with companies that have values that align with our own values. And we're all, you know, we're all employees as well. So we're looking to our employers to say we want employers to do more. And also it's about leadership, executive pay, audits and internal control. So what are businesses doing about executive pay? What level of transparency is there? What level of reporting is there? In terms of the key risks, when I was preparing this, I came across this, what I thought was a really helpful taxonomy of ESG risks that RepRisk has developed. Now, RepRisk is a data science business in Zurich, and they specialize in business conduct risk research. So just looking at that, for example, if we take the social issues column in the middle, RepRisk has said that the areas of risk that businesses need to look at when they're looking at the S and the social are human rights abuses and corporate complicity. They're looking at impact on communities. So what are the risks for businesses on the communities? What level of local participation is there, and social discrimination. And then for employee relations, for example, the key risk areas for businesses are in relation to forced labour, child labour, freedom of association, collective bargaining, occupational health and safety, and employment conditions. So hopefully you'll see, I mean, I found that a really useful summary really of what the key risks are in the supply chain for ESG that businesses are looking at. It's a huge agenda, and there are lots and lots of different issues, and there are lots of ways that businesses are responding to that agenda. So moving on to the mandated position in the UK in relation to ESG specifically, the balance really of the focus is on disclosure and reporting. So many companies, as you'll all be familiar with, are subject to legal requirements as part of their annual corporate reporting. The specific requirements are complex. They vary depending on the type of company, the size of the company. As you'd expect, the more onerous requirements are apply to quoted companies and to listed companies, lesser onerous requirements on medium-sized and small companies, but I suspect that may change going forward. The Companies Act and related regulations like the listing rules, the disclosure guidance and transparency rules require companies to report annually in directors' reports and strategic reports and annual reports. In 2022, obviously the Companies Act has been around for quite some time, but in 2022, the Act was expanded to include sustainability reporting. So large companies, which in this context are listed companies, companies with more than 500 employees or a turnover of more than 500 million, they're required to discuss the strategy, processes, and also the due diligence around sustainability. Companies are also required to report on their UK energy use and carbon emissions through the streamlined energy and carbon reporting. That applies to companies with a 36 million annual turnover, an 18 million balance sheet total, or more than 250 employees. The obligation extends to Scope 1 and Scope 2 emissions within the UK. So that's the immediate use of businesses, but also the emissions in the supply chain. We'll all be familiar with the Modern Slavery Act. That's now been around for quite some time, but again, larger organisations carrying on business, again, that's a turnover of 36 million, have to report annually on their actions. Usually it takes the form of a modern slavery statement, and those statements would usually cover what a business is doing in its supply chain due diligence efforts. There is legislation in the pipeline that would mandate the content of that statement, and that will include information about due diligence processes. And then we've got gender pay gap reporting that we're all familiar with for large employees with more than 250 employees. So there is mandatory reporting for certain companies in that area. So there are increasing moves to ratchet up the compliance, not only by the reporting, but also looking at due diligence, looking at processes and procedures. The Environment Act in 2021 contains provisions that haven't yet commenced to prevent illegal deforestation, including a requirement for large businesses with a applicable turnover to implement a due diligence system in relation to the use of forest risk commodities in their commercial activities, and to report annually on their due diligence. And we're awaiting some secondary legislation on that. And there's also a GB illegal timber regulation, which contains a prohibition on putting illegally harvested timber or products derived from it onto the GB market. And there's a requirement to follow a mandated due diligence system. So before entering into trading arrangements for raw materials, it's becoming increasingly important to undertake specific due diligence on supply chains. Moving on to the non-mandated supply chain reporting that there are, lots of businesses voluntarily undertake supply chain reporting. We've got the ISO 14001, which is an internationally agreed standard that has requirements for an environmental management system. And that's about making more efficient use of resources and reducing waste. We've got ISO 26000, which is social responsibility standard, and that contains voluntary guidance on integrating social responsibility through an organisation. It's not a certification standard, unlike ISO 14000, but it gives guidance on human rights issues, for example. We've also got the Science-Based Target Initiative, so SBTI Net Zero Standard, which is one of the first frameworks for corporate net zero climate setting, which has some basis in science. And that is aiming to give business leaders confirmation that their climate plans are aligned with science, and those net zero targets are going to be met by 2050. Then ethnicity pay gap reporting. Some organisations are voluntarily reporting it, but at present there's no mandatory requirement to do it. The government did consider mandating it, but it has made it clear since that that will not be introduced at this stage, although they are supporting employers with voluntary reporting. We'll all be familiar with the anti-bribery with the Bribery Act 2010, where there's a requirement to assess adequacy for procedures to ensure that companies aren't involved in bribery and corruption, and they've got an anti-corruption policy in place that's regularly reviewed. And also the various non-mandated reporting in relation to management of material ESG risks for incentive plans for senior leaders. So senior leaders are increasingly being asked what they're doing on the ESG front and reporting. Moving on to another certification that's available that some of you may well have come across and may well actually be a B Corp itself. So there is a framework in one area of B Corps where businesses are required to meet rigorous standards in 5 areas. Next slide, please, Lauren. those 5 areas are environment, governance, workers, community and customers. So it is a demanding process. It takes quite a long time to do. There's a lot of scrutiny around businesses that are applying for a B Corp status. Currently, there's around 750 UK businesses so far that have passed this, but the B Corp are projecting around 1,200 this year. The certification is set up by a B Lab, which is a kind of not-for-profit organisation that is aiming to certify that companies meet high standards. And those standards are objective standards and are aimed to be internationally recognised as a marker of best practice. It can take quite a while to achieve. Some of the figures are 6 to 10 months to complete the process. And broadly, the process requires the company has to generate most of its revenue from trading. So it has to be competing in a competitive marketplace. They have to have achieved a verified score in their impact assessment tool. And that looks at a whole range of different things across the business, how the company impacts its workers, its community, its environment, and that assessment is shared publicly. So it's a very public process as well. The businesses have to adopt articles of association that include specific wording that B Lab prescribe, and they also have to sign a declaration of interdependence and pay fees, and those fees do vary by the size of the business. The certification has to be redone every 3 years, so it's an ongoing process. Some of the benefits that have been identified for B Corp is that it gives a very good holistic compliance framework. It promotes improved standards and it uses objective criteria to align to best practice. And one of the interesting things is the PR that's associated with it. Some of the downsides that have been raised against B Corp certification is the time and resources for making the application, the ongoing scrutiny, because it is ongoing, it has to be redone every 3 years. There have been queries that I've seen about whether it fits across all sectors as neatly as it might. It's obviously a very public process, so there's a challenge to confidentiality. And there have also been queries about some of the businesses that have achieved the B Corp status where there are some known social or human rights issues. So the benefits and downsides to B Corp, but that's one example of a certification process that companies are going through. So moving on to the potential roadmap in the future. In terms of occupational pension schemes, the Department of Work and Pensions is committed to review this year of climate-related governance and reporting requirements for large occupational pension schemes. And it's the same with local government pension schemes as well. So we are expecting regulations to come in to implement climate-related governance and reporting requirements. In the EC, there's a proposal to introduce a carbon border adjustment mechanism. So if you are an importer of goods covered by the mechanism, you will be required to buy carbon certificates corresponding to the carbon price that would have been paid had the goods been produced in the EU. And would therefore have been subject to EU carbon pricing. As Chris mentioned, there's obviously this divergence between EU and UK law, but we're expecting that in the UK, the UK is going to be looking at a carbon border approach, and there may be some carbon border adjustment mechanism introduced, but that's a consultation currently. And then we've got the Greener Finance Roadmap for the UK financial system, where the government's committed to make climate-related financial disclosures mandatory. And that roadmap has 3 phases. One is about informing investors and consumers by ensuring there's a flow of information. So first one is information. The second one is requiring the information is incorporated into business and financial decisions. So you've got the information, you then incorporate it into the business. And then the third one is ensuring that the financial flows shift to align to the UK's net zero commitment and its wider environmental goals. So again, for the financial system, we're seeing a phased implementation moving from reporting to integration into the whole way that a business operates. in February 2022, you may well have seen there was a proposal for corporate sustainability due diligence directive. The proposal includes a new due diligence duty to be integrated into corporate policies. So again, it's not just reporting, it's about integration into the whole business. It will be a requirement on certain companies by size and also in certain high impact sectors, and that includes agriculture, minerals, extraction and textiles, to identify adverse human rights and environmental impacts in their own operations, but also those of their subsidiaries and those their direct and indirect business relationships in their value chain. So that's going to be really far-reaching. There'll be 12 reporting standards of disclosure, and there'll be hundreds of different metrics that will require input from lots of stakeholders and the supply chain. And there'll also be enforcement, so sanctions and civil liabilities for non-compliance. The World Wildlife Fund, moving to the next slide, interestingly has said that in their view, this directive provides an unprecedented opportunity to end destructive business practices. So there may well be great things expected of the directive. However, it is EU directive. The UK government has said at present it doesn't intend to replicate the proposal. But it's important to note UK businesses could be caught anyway where they generate turnover in the EU or export to companies which themselves are in the scope of the directive because of the breadth and the reach into that supply chain. So moving then on to the final area, which is the reputational risk that is increasingly a focus of this area. And Quilter is a UK wealth-based management service identified that greenwashed investments or investments that are not what they claim to be were the biggest concern for 44% of investors. So it's a huge issue when we're looking at investment. And then the Competition and Markets Authority found that 40% of so-called green claims made online were potentially misleading. When you combine that with findings that claim that over 2/3 of consumers are prepared to pay more for sustainable products, it's going to be increasingly an area under scrutiny. So a green claim or an environmental claim for a product is a claim that suggests that the product is better for the environment, or it's got a positive impact, or it's less damaging. There aren't any specific laws against greenwashing, but it's governed by a combination of consumer and business protection laws, and also by the advertising, the CAP code and the broadcasting code. And in general, adverts have to be honest, they have to be truthful, they have to be not misleading. In the current climate, if there are breaches of the CAP codes, the ASA, the Advertising Standards Authority, can't levy fines, but it can do other things. So it can publish a weekly ruling, so reputational risk. It can require businesses to change their adverts, which can be quite costly. It can ask the media owners to withhold advertising space, and it can ask social media companies to have content removed. So there are some things it can do. In April 2022, the government announced plans to give the CMA more power to enforce consumer protection legislation directly without the need to go to court. So the CMA would be able to fine businesses who breach consumer protection laws and award compensation to consumers, and fines could be up to 10% of global annual turnover. So, you know, it's the potential, the risk in this area is increasing. So the regulators are likely to continue to respond. There will be more rules to eliminate misleading and unsubstantiated claims. There's a current investigation in the retail sector. So ASOS, Boohoo and George, Asda, there's claims there are being investigated, and that's likely to conclude this year. And the CMA has also said they've also flagged the travel industry, the transport sector, and fast-moving consumer goods as areas that's likely to come under increasing scrutiny going forward. So to summarise, the mandatory regulation is significant around reporting and disclosure. There is definitely a move towards requiring due diligence along the supply chain and integrating due diligence into policies, practices, and procedures. There are increasing requirements to identify potential adverse impacts on human rights and the environment. The trend is absolutely clear. There will be sanctions, there will be enforcement, and the sanctions could be financial based on the company's turnover, with significant consequences for getting it wrong. So that concludes what I have to say on ESG and the supply chain. I'd now like to hand over to Jeremy, who's going to lead us into the topic of economic crime and transparency.
Thank you very much, Paula. So afternoon all, and I'm here just to talk about the up and coming Companies House reform that will probably have an impact on the businesses that you work in, and also if you're looking at other businesses, then it will affect those as well. So first slide, please. First slide line. Great. So what is it, in terms of we're talking about? So it's the Economic Crime and Corporate Transparency Bill. So where is it? So it's actually it's just moved actually from the committee stage into the report stage in the House of Lords. So when do we expect it to come into effect? So it's sort of been moving. We initially thought it was going to be in place for May. That's obviously not going to happen now. So we're expecting it later this year. But it's obviously in the House of Lords at the moment, so it's made progress. What does it look to cover? Well, actually, Companies House doesn't have many powers to deal with inaccurate information. What they've come to realise as well, as part of financial crime, that Companies House has been used as a tool to launder money, and they want to give some more powers to Companies House to help deal with that. Next slide, please. I think the key quote actually out of the bill is that, and the report, is that Companies House will no longer be a passive administrator of company information, but will become a much more active gatekeeper of company creation and custodian of more reliable information on the register. I think in a nutshell that explains what their aims are. So what are they looking to do? Well, they're looking to implement identity verification for directors and also persons with significant control. And they're looking to really tightening what they feel is a gap with Companies House. They're going to try to extend Companies House the powers that it has, so it might be able to actually make changes itself, rather than where at the moment if you have something that's erroneous on there, then they have little powers to do anything about it. It's then going to we're going to talk a little bit about later about companies' accounts and the impact it's going to have on that, and also personal information. So next slide, please. So the key aim really is that the accuracy in the information on the register is improved. So we talked a bit about the role and powers. I think the other bit is to deter abuse and deal with the ownership transparency element of it. At the moment, where they previously had annual returns, they changed that. It's not easy to find out who owns a business. I think this was probably discovered during the period where sort of bounce back loans or COVID loans were being implemented. There's been a huge amount of fraud. So those are sort of the main aims. And then I think they've added in there about user experience and to go digital, really, to make it a bit more easier in terms of filings. Next slide, please. So who's going to be covered by this? So actually, we're going to be looking at existing company directors, anyone that's put on there for new directors, PSCs, so we already mentioned persons with significant control, so shareholders of companies, and it's then going to also impact on people that file with Companies House, so lawyers, accountants, and actually individuals that look to update and file on the company's register. You're going to have issues unless you actually register with Companies House, and they're looking to verify who those people are. And we've talked a bit about corporations where previously you could for £12, incorporate a business with very limited information. That's going to change, and you're going to need to give more, I guess, identification behind that. So gone are the days where you might have a PO box with lots and lots of incorporated businesses. Actually, there's going to be a bit more bite in the company's house in order to establish who those people are. Okay, next slide, please. So this is an example of what they're looking to bring in with the bill, and obviously I suspect it will come into play because it's already in place for passports. And if you think about banking apps and how they've developed, actually this is a very similar system. So the idea behind this is that you set up an account, and then you using their sort of their tech, you would then verify your passport or driving license, and then you would go on the company's house register as someone who's verified. So that's just an overview of how that's looking to be implemented. Next one, please. So the next bit is around how this impacts on individuals. So if we were looking to appoint someone to the board, what you can do is you can either hopefully pre-verify these changes coming in. So you would effectively set up an account, verify your identification, and then if the new director was appointed, then you could just be put straight on because you'd already have an account. And that's the idea and checklist behind it. So next slide, please. So the PSCs, actually what you've got here is that any existing PSCs will have a time frame in which to verify. So that will cover off those people that are on at the moment. And if you don't do that within the compliance period that they give us, then there'll be effectively a breach and potentially criminal offence, or and as well as a civil penalty. So that's for existing. And then any new PSC providers, what they're talking about is a 14-day period in which to then verify. Otherwise, you'll effectively have a status that's not verified. And it should be easier for people checking the registers to work out what, who the PSCs are and whether they've been properly identified. Next slide, please. So one of the points as well, this has come out of the proposed changes, is they're looking to clamp down on sort of corporate directors. So actually what they're looking to do is, where this is particularly involved with sort of limited partners or the general partners, etc. What they're looking to do is actually verify the individuals over and above that. And I guess this whole thing is that they're looking to clamp down on loopholes, really, where you might be able to have an incorporated entity to the corporate director and not really have much behind it. So that's what they're looking to clamp down on. Next slide, please. This isn't necessarily relevant for those on the call, but effectively what it's going to mean is that it will make it more difficult for lawyers, accountants to just make changes to the register without effectively having some form of account. So we will have law firms will have an account with Companies House, and it will be a bit like an extension of anti-money laundering provisions. So we'll have to make sure that we do verification checks on those that we're appointing. But I think we wanted to mention this on the call because actually it will slow things down. And I suspect that, whereas before on opening of the matter, you do your identity checks. Actually, when you're going to put on a potentially new director or make changes, then that will need to be forthcoming at that point. So it could slow things down and also make people aware of that in respect of third parties. Next slide, please. This is quite an important reform, and I think it's for the following reason. So what they're looking to do is now with accounts, it's looking to be filed electronically. And so there's a certain digital software that everyone will have to use. And I know there's been some concerns. So when you read the Q&A around this proposed bill, people are concerned that on smaller businesses, they just don't have that software. So I think Companies House are looking into, when they implement this, looking into sort of free software that will be able to sort of have accounts in that form. The other key thing here is that actually small companies will no longer be able to not file a profit and loss. So, I mean, I've seen other notes from accountants where they're saying actually there's going to be a lot more transparency around the profit of the business, etc. And the idea, the reasoning for that is to stop businesses pretending that they're a profitable business and taking advantage of other companies or using it for crime. So that's quite an important reform, I think. The other final thing to mention as well is that you can see that they're looking to stop people moving around accounting periods, and that might have a knock-on effect in your business if your business, tends to change accounting periods every so often. That's something else to be aware of, and that might not always be the case in the future when this gets implemented. Next slide, please. So really just building on what rules we have around data, and in the old days you used to have people's signatures on Companies House, but actually what the bill's looking to do is to strip that back. So you can see on the slide that actually we've listed some of the points that we're looking to suppress, I guess. So occupation, most people tend to put directors, but that's now coming out. And then we're looking to basically remove data, so it can't be used in a bad way from the internet. So that's the key thing in respect to privacy and what might come down the line once the bill's been implemented. So next slide, please. Yeah, so just to sort of summarise really, is we've put a link in there in respect to changes and where you can get access to it. So at the moment, it's not in force, but it's due to come into force. So I think it's something that you should be aware of. Keep checking in with us to understand where it is in its journey, because eventually these changes will come in. I think we've seen from some of the government's changes on other things that this isn't going to go away, that actually changing things to be a bit more digital and transparent is definitely an approach that we're going to see. So I think that is it.
Thank you very much, Jeremy.
Thank you.
That brings us nicely to questions. There have been we do have some questions that have come in. Perhaps Jeremy, if I could, since you've just been speaking, address the first one to you. What's the time frame for implementation of the proposed changes at Companies House?
So it's quite a difficult question to answer actually, because I guess it's how long is a piece of string at the moment. So where we are with this is that it's currently with the House of Lords, so it's not been implemented yet as legislation. But I suspect that once it does get implemented, then we'll have a bit of a better understanding in terms of when it's coming into force. But the idea behind this was that it was going to be this year, but actually I suspect because of the time frames, it's probably not going to be as soon as we thought.
Okay, super, thank you. Danielle, there's a question for you on the NSI Act. What are the penalties for non-compliance with the NSI Act?
So there's both civil and criminal penalties. So non-compliance with the mandatory notification can result in fines of 5% of worldwide turnover or £10 million, whichever is the highest, and up to 5 years in prison for the acquirer. In addition to that, transactions which are covered by the mandatory regime, which are not notified and complete without clearance, are void, which means they're treated as if they haven't happened. So obviously that can be quite a big risk if you spend a lot of money on a transaction.
Yeah, okay, thanks very much. And then Chris, I'll pick out one for you on data. Is there a danger that the proposals outlined in the data protection and the digital information bill could pose a threat to the UK's adequacy status for purposes of EU GDPR?
Thanks, Paula. The answer is yes. The problem is that the UK went through the adequacy process with the EU, and that basically requires the EU to take the view that the UK's data protection rules are equivalent or provide equivalent protection to those that are in place in the EU. And they found the EU did have adequate protection in place based on the UK GDPR. That decision comes up for renewal in 2025. And the concern is that these amendments that I was talking about in my talk might actually move the protections offered by the UK data protection regulation away from the strict correspondence with the EU rules. Having said that, during the during the committee stage of the current bill, the UK ICO, John Edwards, was actually asked that specific question, and he said that he didn't think that the proposed amendments to the regulations actually put the UK adequacy ruling at risk.
Right, okay, thank you for that. And that brings us nicely to 1 o'clock and our finish time. To the extent we haven't answered any of your questions, we will come back to you. So that all that remains is for me to say thank you very much for taking the time to listen to us. Please do let us have any feedback and any questions. And if there are any other topics that you would like us to address in any future sessions, then please do let us know. Thank you very much.